Hi, my name is Bree, and I have worked as a special education paraprofessional for the last 4 years with students with different abilities. I am currently returning to school to finish my degree in elementary education and special education. I'm a mom to two boys, one of which has ADHD and autism himself. My life is a little busy, but special education has always been a big part of it, as my sister had epilepsy and multiple learning disabilities, and I always wanted to help her when I was younger. And now I'm navigating it again as a parent trying to help my son. Although special education has come a long way since helping my sister to now helping my son, there's still progress to be made to ensure services are truly individualized for every student. This video will provide a brief overview of the history of special education law, highlight important court decisions, and share a few helpful resources for families. Prior to the 1970s, before federal protections, many children with disabilities were excluded from public schools or placed in segregated institutions. Families had little legal protection and limited ability to challenge schools' decisions. Two landmark cases that changed this was Park versus Pennsylvania in 1971, which established that students with intellectual disabilities had the right to a free, appropriate public education. Mills versus Board of Education in 1972 ruled that students with disabilities have a right to vape regardless of the district's funding or financial constraints. These both of these court cases led to the decision to the Education for All Handicapped Children Act of 1975, which later became the Individuals with Disabilities Education Act, or IDEA. The IDEA guarantees free, appropriate public education, or VEP, education in the least restrictive environment, LRE, individualized education plan programs, IEPs, and parent participation and procedural safeguards. In Board of Education versus Riley in 1982, the Supreme Court clarified that schools must provide meaningful education benefits. In Andrew F. versus Douglas County School District 2017, the court strengthened this standard by stating that IEPs must be reasonably calculated to enable appropriate progress based on the child's circumstances. These cases reinforce that education must be individualized and designed for meaningful growth. Andrew F. versus Douglas County School District in 2017 was also a case that emphasized that students are entitled to more than minimal progress. Schools must design IEPs that support meaningful advancement. This strengthened parental advocacy rights and accountability for schools under the IDA. Students placed in private schools by parents' choice are also entitled to child-find evaluation, but they do not receive the same individual entitlement to vape as students in public schools. Instead, services are provided through a proponent share of IDEA funding. This distinction affects service delivery and highlights the importance of parents' awareness and consultation processes. To stay informed about special education laws and current trends, the following resources are very valuable. The Virginia Department of Education, Special Education Department, provides state-specific guidance, procedural safeguards, and updates. Rights Law offers explanations of IDEA, court cases, and parent advocacy information. ADA.gov provides information about disability rights under the Americans with Disability Act. And Understood.org explains IEPs, 504s, and the school's right in parent-friendly language. Special education law has evolved significantly over time due to advocacy, court decisions, and federal legislation. These protections ensure that students with disabilities receive individualized support and meaningful educational opportunities. Families are essential partners in this process. Understanding these laws empowers parents to advocate confidently for their children and collaborate effectively with schools. Thank you for the time to learn about these important protections.